That was 11 years ago. The flow of corporate money to judicial elections was then just a trickle on its way to becoming a river, which would soon become a flood. Since our report in 1999, for example, 9 justices currently serving on the Texas Supreme Court have raised nearly $12 million in campaign contributions. The race for a seat on the Pennsylvania Supreme Court last year was the most expensive judicial race in the country, with more than $4.5 million spent by the Democrats and Republicans. Now, with the Supreme Court Citizens United decision, that corporate muscle just got a big hypodermic full of steroids. Here to talk about the Supreme Court decision and judicial elections is a journalist well-schooled in the law. Jeffrey Toobin is himself a lawyer and a former assistant United States attorney. He now covers legal affairs as a staff writer at the New Yorker magazine and is senior legal analyst for CNN. For the New Yorker, Toobin has profiled those 2 Supreme Court justices I interviewed for FRONTLINE, Anthony Kennedy and Stephen Breyer, as well as Chief Justice John Roberts in this article headlined, "No More Mr. Nice Guy." He's also the author of this bestseller, The Nine, Inside the Secret World of the Supreme Court, the latest of his 5 books on politics and the law. I've said this before in the name of full disclosure, and I'll say it again. I have known Jeff Toobin since he could barely reach this tabletop. Welcome back to the Journal. You just heard Justice Kennedy interviewed 11 years ago when he said to me, big problem, this problem of money in judicial elections. And now he's just written the majority opinion in Citizens United, taking the lid off of what corporations and unions can spend in elections. Do you think he has any understanding of the implications for judicial elections of the decision he just wrote?
Well, I think he understands it, but what the Constitution is always about is balancing interests that sometimes conflict with each other. And under his interpretation and that of 4 other justices, he says that corporations have these close to absolute free speech rights. So even though that may lead to additional corruption of our elections, that's what the Constitution commands. But that's not the whole story here. And in fact, the government has regulated political speech by corporations for 100 years, since 1907. So it's not like free speech is an on-off switch. We have lots of people in our society who have some free speech rights, but not complete rights. Students, prisoners, government employees. They all have some free speech rights and not others. Corporations. But to participate in the political process, there have been limits for decades, and that hasn't been a problem until now.
What do you think this recent decision means for judicial elections in particular?
Well, I think judicial elections are really the untold story of Citizens United, the untold implication. Because when the decision happened, a lot of people said, okay, this means that Exxon will spend millions of dollars to defeat Barack Obama when he runs for re-elections. I don't think there's any chance of that at all. That's too high profile. There's too much money available from other sources in this race, in a presidential race. But judicial elections are really a national scandal that few people really know about, because corporations in particular, and labor unions to a lesser extent, have such tremendous interest in who's on state Supreme Courts and even lower state courts, that's where they're going to put their money and their energy, because they'll get better bang for their buck there.
Well, I know you don't read minds, but is Kennedy unaware of what this could mean for what he just said, the integrity of our judicial system?
Well, he's more aware than practically any justice on the court, because just last year he wrote an opinion about the abuse of money in judicial elections.
That was the West Virginia case where he said a Supreme Court judge in West Virginia must recuse himself, remove himself from deciding a case involving a campaign contributor who'd given $3 million to the judge's campaign.
Right. I mean, the facts in that case were so egregious that the court, which really doesn't like to get involved in specific races, couldn't look away. It was so awful. As you said, there was a $50 million judgment against a coal company. The CEO of that coal company, knowing that case was coming up for appeal, knowing how divided the court was, put $3 million of his own money into supporting one candidate. That candidate won. That candidate was the deciding vote in the case. And the losing side said, look, this is a violation of the law, a violation of due process of law. And the Supreme Court, in an opinion by Justice Kennedy, said the appearance of that justice in that case was just so bad, even though they couldn't prove he'd been effectively bribed, they overturned the case.
What Justice Kennedy said, by the way, just one line in the Citizens United case, he said that it's important for the judge to recuse himself, but it's also important that we not limit the political speech of the person who is contributing to his campaign. So he's making some kind of distinction there.
Well, you know, again, apparently, to use a famous phrase associated with the Supreme Court, you know, he knows it when he sees it, like, what's too much of a campaign contribution? You know, when does the money get so egregiously out of whack that you have to, the judge has to recuse himself? But, you know, the logical extension of that argument is that they should all recuse themselves, and obviously we can't have a system like that. So that's why, though the West Virginia case is illustrative, recusal is only an answer in a handful of cases. It's a systemic problem, not an individual problem.
What do you think, as an attorney and as a journalist, about that decision, the Citizens United decision?
One of the things about what it used to mean to be a judicial conservative was that you believed in judicial restraint. You believed in judges deferring to the elected branches of government whenever possible. George W. Bush always used to say, I want judges who interpret the law, don't legislate from the bench. This was judicial conservatism in an activist mode. Because here, this was Citizens United was evaluating the McCain-Feingold bill, a big part of it, which was passed by Congress very recently, signed by President Bush.
2002, in fact.
Right. Signed by President Bush. Parts of it had been approved by the Supreme Court before, but the conservative majority said, we know better. When you had justices like John Marshall Harlan, who was appointed by President Eisenhower, or Justice Potter Stewart, who was also appointed by President Eisenhower, they did believe in backing away from what the legislative branches did. This seems a much more agenda-driven conservatism, where if the legislature doesn't do what they want and interpret the Constitution the way they want, they are going to impose it. And that's what's so striking about this opinion, is that this is exactly what liberals used to be accused of doing, which is rewriting the laws to favor the side that they want. But here you have supposed conservatives doing it.
This majority did not have to resolve this case this way. It could have resolved the Citizens United case very narrowly on whether that Hillary, the movie film, could have been denied access to cable channels before the election. But the court reached out and said, we want this case. And they gave a much broader interpretation to it than they needed to do. Do you think that was Justice Kennedy, or was that the machinations of Chief Justice Roberts?
Now, I don't want to get too much into the weeds here, but you know, if you saw how this case was dealt with in internal Supreme Court matters, it was very extraordinary. They argued it once on the narrow issue of, does it apply to this one-time pay-per-view cable possibility? And then they asked for re-argument. This court almost never asked for re-argument, and they asked for re-argument on the much broader issue of, you know, do corporations have free speech rights, and does McCain-Feingold violate those rights? I think John Roberts' fingerprints were all over the change here. And yes, this opinion was written by Justice Kennedy, but I think the moving force behind it was the Chief Justice.
But what do you think was behind his decision?
I think he thinks that First Amendment law, when it comes to corporations, has been off in a wrong direction. And he saw this case, wanted to change it, and use this case as a vehicle. I think it means that there are entire areas of the law that he believes need to be changed, and need to be fixed, and need to be improved.
Irrespective of what he said about precedent?
You know, I think the words will live in infamy that he said in his famous opening statement at his confirmation, where he said, I'm just like a baseball umpire. I don't make the rules, I just call balls and strikes. And he talked about his love and respect for the rule of precedent.
Nobody ever went to a ball game to see the umpire. Judges have to have the humility to recognize that they operate within a system of precedent shaped by other judges equally striving to live up to the judicial oath.
He's got an awfully expansive view of what baseball umpires do. He's acting a lot more like the commissioner of baseball than an umpire. Because if you look at all these areas, he's trying to make big changes. You know, he's now been on the court for a substantial amount of time, almost 5 years.
Right.
Abortion rights. affirmative action and racial preferences. Now, First Amendment rights for corporations. He is interested in dramatic and immediate changes in these areas. Now, he doesn't always have 5 votes, but he's trying to get them every case.
You said in that article you wrote for the New Yorker last year that Justice Roberts is a doctrinaire conservative who, in his 4 years on the court, now 5, has served the interest and reflected the values of the contemporary Republican Party. And in practical terms, you said, in every major case, he has sided with the prosecution over the defendant, the state over the condemned, the executive branch over the legislative, and the corporate defendant over the individual plaintiff.